Test, test, 1, 2, test, test, 1, 2. Test, test, 1, 2, test. Test.
I went, I don't know, what, Sydney, like a year in, you forget
Yeah.
where you go.
Actually, I was a little bit opposite. I decided when I was 6 I wanted to go to law school, and then I started getting in that regret phase about a month before it started.
Oh, is that right?
But you persevered and decided to go anyway.
Yes.
Okay. Yeah. But you did in Duquesne.
I did.
Yeah, and which is in Pittsburgh.
Yes.
Cool city.
Yeah, great
Yeah.
city.
Anybody been? You been to Pittsburgh?
Have
Yeah.
you? Cool.
Yeah.
Cool.
Yeah. Three Rivers, right? Isn't that Pittsburgh what it's known for? And, yeah.
Yeah, and snow and Steelers.
Oh yeah. Oh
and-
yeah. Yeah. Oh
Yeah.
yeah. The football team. Yeah. Yeah. We got a bad thing against the Steelers in Houston. If you didn't know,
I don't think
Well,
I
you're not
heard
old enough to
that.
know. Nobody in here is old enough to know. I'm the only one old enough to know. Well, the Houston football team got to the National Football League championship 3 or 4 years in a row, only to lose to Pittsburgh
that right?
each time.
I don't even think I knew that.
No, it was tough. Was it Pitt? I think I'm not sure it was Pittsburgh. It wasn't Pittsburgh, it was Buffalo, but I'm pretty sure it was Pittsburgh. And they came awfully close each and every time, but Pittsburgh kind of stood in the way. It was tough.
Yep.
Tough. Well, welcome to Houston anyway.
Thank you.
Yeah? So how'd you end up in the employment law arena?
Well, I started out in litigation. I worked at a civil litigation firm, and we did some employment defense where I represented companies that were sued by their employees. And I guess over a couple years of doing that and just feeling like, you're sitting there and you're looking down the end of a potentially huge damages payout for your client because, one of their supervisors asked a bad question in an interview or something, and just thinking, it doesn't have to be like this. This company should never be a defendant in a lawsuit. And I think just, 9 out of 10 times I would feel that it was sort of just because of a lack of knowledge. These companies and their supervisors and managers just didn't have a good grasp on employee rights and the employer-employee relationship. So when I moved to Houston 2 years ago, I decided to start my own practice, sort of working on the front end of that and helping employers basically prevent employee lawsuits. Now, obviously not every lawsuit is 100% preventable, but they're definitely foreseeable.
Sure.
And these suits don't come out of nowhere. And I think a lot of times people don't have the foresight and really look into it and make themselves aware of the employee rights until they're sitting as defendants in a lawsuit, potentially having to pay hundreds of thousands, sometimes millions of dollars, especially if it's a class action lawsuit. So that's how I got there.
Yeah, that's great. So you're focusing now on training, education, compliance.
Exactly.
Good.
Yeah.
So that's good, and that's good for you guys, right? Because that's one of the things we talked about is trying to prevent these things from happening before they do. Yeah. So good. So speaking of the employer-employee relationship, which is interesting, especially now.
Mm-hmm.
We don't have to go into why, but yeah, everybody knows why. But let's go ahead and jump into this concept called employment at will, because I think that's often misconstrued. I think, from my perspective, employment at will is we can hire and fire for any legal reason,
Right.
not with total discretion.
Right.
Does that sound right?
That sounds right.
Does that sound right? So, give me an example of terminating somebody that's legal. They stole money. Okay,
That's good.
keep going.
Sexual harassment.
Okay, they violated company policy. Fair? Yes, very good. What else?
Show up under the influence.
Okay, employees would never do that, would they? Right, all right. What else?
Constantly showing up late.
Yeah, so we have lots of different for cause reasons. But here's the thing, under employment at will, do we have to have cause in order to terminate somebody?
What if I don't like the color of the shoes you wore that day? Can I fire you? Why not?
If it's for you.
Say
I was
there's
gonna
no
say if it's
uniform.
part of your dress
That's a
code.
good point, yeah. Say there's no no uniform. I just didn't like the color of your shoes. Thought they were ugly, it offended me.
Does it impact their performance?
Does it matter? Yes, I can fire you if I don't like the color of your shoes. Because it is an employment at will relationship. For cause or without cause. Notice or no notice. I can let you go for whatever reason I want, provided that it is a legal reason. Maybe the better way to say that is provided it's not an illegal reason.
Illegal reason, okay,
Yeah.
that's a fair way to put that. So let's talk about some illegal reasons. What if she, instead of Lexi saying, I didn't like the color of your shoes, she said, I don't like the color of your skin? Illegal, right? Okay, and where do we look to for those illegal reasons?
Like for the protected classes, sorry?
Okay, Civil Rights Act, right, 1964, it's been amended, we've got some other things. What other types of laws does the chapter discuss that offer protections to employees? The Americans with Disabilities Act, Title I, right, what else? Yeah, which stands for?
Age discrimination?
An Employment Act, very good. At what age does that begin to kick in and protect people? 40, right, very good. Anything else? I want to talk about two other areas, and let's go ahead and get into them since we're here. But let's see this, since we've been in war for a long time now, we've had a lot of veterans returning. And we've had a lot of veterans that have, guards people that have been called up to go. Can you talk a little bit about you, Sarah? I know, am I putting you on the spot?
A little bit.
A little bit, yeah. The Uniform Services Act, yeah, there's protection there. So that's just something I just want you to be aware of. I don't expect you to know a whole lot about it. But it's, you have an obligation to protect that position until they come back. And that can be challenging. So be on the lookout for that. And then what about pregnancy? Is it protected?
Yes, absolutely. Pregnancy is considered a temporary disability under the law. At this point, I know it sounds funny, you're laughing when I say that, but yes, pregnancy rights have come up a lot lately, and that's definitely, a pregnant person is a protected class. Employment law really focuses on who is a member of a protected class. And so I think that's something we'll get into, but it really throws people off a lot because they hear something and maybe it just sounds wrong to them, sounds unjust, but if you're not a member of a certain protected class under the law, then you can be you could be fired for any reason. But if you're a member of that protected class, you cannot be terminated for being a member of the protected class. Basically, employment law is meant to protect people who have characteristics that they either cannot change or shouldn't be expected to change just so that they can be employed.
That's a good way to put that. Yeah. So look, if I said, in most states, can I say I'm not going to hire you? We've been focusing on firing, but it's also, I don't have to hire you, right? If I don't like the way you do certain things, or the shoes you have on, or the way you style your hair, or things like that. But can I say, I'm not going to hire you because you smoke? We don't everybody speak at once. What do you think, Michael?
Nope.
I cannot do that.
Well.
So
it's
what
something you
would
can
be
change.
the, yeah, right, so
Something you can change.
what's,
What?
say that again.
Something you can change.
It's something you can change, right?
So-
It's a powerful habit, but you can't change that, right? So, and is smoking a protected class? People that smoke. Now, certain states have passed some legislation that protects the rights of people to do things outside the workplace, including activities outside the workplace. But Texas isn't one of them. right? So, and many other states haven't either. They don't protect people that smoke. So yeah, you can do that. But that's just an example of how you can exercise discretion under this employment at will concept. And it's one of the most powerful tools that an employer has. Yeah?
Sure.
Yes, ma'am.
Okay, I read this news. It's funny. This lady is a teacher at an elementary school, and the school found out that she works as a stripper
Okay.
and fired her.
Yeah.
Is that legal?
What do you, well, first
She-
of all, working for a school is a little bit different if it's a public school. But what do you think? Is being a stripper, being a member of a protected class? Are strippers protected?
Yes.
Maybe in Texas, probably in Houston, but generally, no. Unless you wanted to make the argument, Lexi, could we really stretch it and say that women are predominantly the strippers? So it's really a sex-based discrimination thing, right?
Yeah, I mean, that's why there's litigation. And,
Yeah.
and I don't know if you guys felt this way when you were reading the chapter, but almost never is there a completely clear answer.
Yeah.
That's why there are two sides to every lawsuit. Every lawyer learns to be able to look at a set of facts and argue it from both sides. And so that's the thing about employment law and pretty much every other area of law, that's always subject and open to interpretation.
It's big time. All right, well, but that's an interesting question. If you're
Yeah.
looking for an answer, it probably, they could get away with that. She may have ended up suing them, but we don't. I don't know. Do you know the outcome? Did she sue?
No.
You don't know, yeah. Oftentimes, now, all right, let's go to there, and we'll use this, and we'll get back to it in just a second. So, there are a couple of ways to modify the employment at will situation,
Right.
right?
That's what I was just going to say about that. For that teacher, potentially she would have a claim if she had an employment contract. And the employment contract modifies the at-will status of every other employee. That's one of the ways to overcome at-will employment. Typically, you're automatically considered at-will unless there's a contract to the contrary. So, but you do have to be careful, because sometimes even just a conversation with somebody can lead an employee to believe that they have a contract for a term of employment with your company. If you're just having just a off-the-cuff water cooler conversation with somebody and you're their supervisor and you say to them, you know, we'll be seeing you around in the next couple of years, or lead them to believe that they can't be fired this afternoon for not liking the color of their shoes, then they might potentially have a claim there.
It's challenging, and so you want to realize that employment agreements, and many of you will sign them, you have to read them carefully, and you have to understand what they do to the employment at will concept, because it could affect your rights. It's going to change the employer's rights, but it's also going to change your rights. Oftentimes it'll address notice, it'll address non-compete, it'll say that you can't go out and do the same kind of work someplace else for a certain amount of time, for a certain radius around your business. So you have to be cautious about things you sign. It's challenging though, because oftentimes an employer will say, here, sign this, and you'll say, well, can we change this? And they'll say, no. And then you have to decide if it's kind of take it or leave it, and you're going to have to decide if you want to do it, right? But the other way to change, to modify the employment at will, is a collective bargaining agreement.
Yep.
Is that fair? Yeah.
Yep.
And you saw that at the end of the chapter where we talk about unionizing, collective bargaining, and we'll talk about that then in just a bit. All right, good. So the point I was making with your situation is she may very well have some sort of an employment agreement that talks about disqualification concepts, and one of those might be behavior outside the workplace. Since it's a school, I can see that being justified and probably upheld, don't you think?
Probably.
Yeah. See, a lawyer's never going to say absolutely. They're
Yeah.
going to say, a lawyer's got a right hand and a left hand for a reason. They're going to go on the one hand, and then on the other hand, and that's how it works. All right, good. So let's jump back then to the beginning of the chapter, and let's talk about job descriptions, and why are those so important? Why do you guys think they're important? Kind of put some things together in the chapter. Why do you think job descriptions are important? Give me an example of when they're going to really matter.
Something kind of like an agreement. It's a list of primary responsibilities of the person,
Yeah,
of the position.
exactly. So it's the primary responsibility. What's another term for that that we use that's coined under the Americans with Disabilities Act, Title I? Did you guys connect those dots? Essential functions, exactly right. The essential functions of the job, right? Okay, so why is that important? Lexi, you probably end up with some litigation around this before, or around things like that.
Yeah, I mean, having a well-written job description is important for a lot of reasons.
Yeah.
But one of the most important reasons is it sets, well, first of all, from an HR perspective, it's good because it helps you sort of flesh out exactly what it is that you're looking for. If you can have it on paper before an applicant even comes in for an interview, you're going to be much better able to focus your interview and not get caught off guard in some tangential issue that might lead you down a bad road of questions or topics that you shouldn't ask or you're not legally really able to talk about. The other part of job descriptions that's really good is it sets sort of an understanding between the employer and the applicant of what the terms of the job and the requirements of the job are before the person even applies. That really sort of helps everybody be on the same page, and there aren't really any surprises that can come up either in the interview or if that person's hired and then during their employment.
That's good. So one of the key things that you have to make sure about your job descriptions is that they're accurate and that they're truthful. So one example would be, let's say in your essential functions of your job description, you said that a person needed to be able to lift 50 pounds. But if I came and worked the job and I did it for a couple of weeks, the heaviest thing I ever needed to lift was 5 pounds. Is that problematic? What could I be doing if I say it's 50 pounds when it's only 5 pounds?
Splitting the unprotected class.
Exactly.
Which ones?
Well, I mean, I don't know, disabled too, I mean, you can.
Well, it could be. It could be people with disabilities, could be people with prior injuries if they're protected. It could be the people that are, let's say, more mature rather than elderly. Thank you very much. And in some cases, some people would argue women. And then they'll probably get slapped with the sexist label. But nevertheless, it's kind of the way it is, right? So the point is that they have to be actual functions that need to be worked. So when you build these, it's really crucial that you do them very carefully, as Lexi pointed out, because they really make an impact. They also make an impact, where I wanted you to connect the dots, was in the Americans with Disabilities Act, Title I, because in order for somebody to be qualified to get the protection under the law and reasonable accommodations, as you guys all pointed out in your posts, is they need to have a qualified disability first, but also they need to be able to perform the essential functions of the job with or without a reasonable accommodation, right? And so you have to refer back to those job descriptions and the essential functions, and they have to be accurate. Because as Laura pointed out, it's very easily discriminatory against people with disabilities if you magnify or exaggerate what they have to do. Yeah, yeah. So those are pretty important things. Yes, ma'am.
So back to the smoking thing, could you write in the job description, no smokers, please?
Now, would that be in the job, or would that be in another area? Yeah, so you're trying to do two things. You're trying to describe the job and the essential functions, and then the other area. Yeah, then we're talking about, what do we call those? Job qualifications, but we use a special term. Yeah, you know, what does bona fide mean? Legit, real, right? Just a fancy word for real or legit, accurate, actual, yeah? So, yeah, that's a good question. So my perspective, Lexi may feel differently, is that, yeah, you can say non-smokers only. We certainly do when we hire people in our businesses outside the university. Lexi, what do you think about that?
I think
In
you
Texas,
can.
yeah.
Yeah, I mean, you can say, no smokers, please, to weed them out from even applying, or you could just have a policy as, you know, no smoking during work hours, no smoke breaks provided policy that would weed them out in that way. But actually, it probably is better just to say it so that they don't, again, smoking is not really discriminated, or is not a protected class, but better to not even have somebody think that they were discriminated against for whatever basis. Because, you know, a lot of times people can find a protected class that they want to be a part of if they want to file a discrimination lawsuit. And so sometimes it's better just to put it right out there.
That's a very good point. So what are some other BFOQs, bona fide occupational qualifications? What are some others?
Education.
Level of education that you want, right? Good. What are some others?
Previous experience.
Experience, number of years in that particular arena, very good. What else?
Certification.
Certifications that you might expect them to have. What in our business, what are some of those? Which one? Yeah, food handler sanitation, right? Responsible service of alcohol. Good. What else?
So with the alcohol would be like a minimum age.
Yeah, have to be, if you're going to be serving alcohol, minimum age. Can we establish a minimum age, given the ADEA? Yeah, right. Yeah, because the ADEA only comes into play when? Mm-hmm. Right. Can I say must be 30 years of age?
What if I said, because we were talking about education, if I said a qualification for being a bartender is that you have to have gone to college, 4-year college degree. What do you think of that? Is that okay? Why not?
You're weeding a lot of people out if you say that.
Right. Right. Education is very touchy, and you really want to be sure that when you put an education requirement on a job description, that it is actually necessary for the job. So what happens is a lot of times employers will want, you know, certain type of person and say, well, this certain type of person in my mind would have a college degree. A lot of times that ends up excluding, you know, members of certain protected classes. And so you have to be really careful with education. If you need a certification, or, you know, the education is required for the position, then by all means say it. But make sure, because it's just sort of human nature sometimes for people to include that, and you think, well, it's schooling. How could that be discriminatory? And the law believes it can be. Yeah.
Like, you can exclude certain groups under certain circumstances, such as stripper. Like, you could exclude males, right?
To be
Oh,
a
you mean like
stripper?
Hooters or somebody like that?
Oh, they got
Yeah.
big time for that.
Well, that's challenging, and we run into those, but that's, and there's a lot of litigation around that. And so they try really hard to establish BFOQs, and that's really what they rely upon. Somebody told me the other day, I don't know if this is true, but they told me, what's the other joint like Hooters?
Twin Peaks.
How do you guys know that so quickly? You didn't even have to get it out of your brain, it was right on top.
I did a case study back then.
Oh, you did? Yeah, that's a good answer, Michael.
Because
Michael.
there's also Tallywhackers, which is the male version.
Tallywhacker.
I've heard
All right, that's a
that.
new one on me.
Up in Dallas.
All right, Michael, I'm a little worried about what you do with your spare time. But the challenge is how do you, so somebody told me Twin Peaks establishes, they call their servers models
Yeah.
rather than servers. And they try to establish BFOQs for models rather than servers, and that's how they try to sustain it. I don't know if anybody sued them or not.
Sort of, yeah. So this is actually a very, very interesting area because in my opinion, the law is wrong.
Yeah?
Yeah. Okay, so just to be clear, a BFOQ, does everybody understand what that is? Where we're saying, yes, we have an admittedly discriminatory policy. And by the way, there are two types of discriminatory policies, just so that everybody's clear on this also. There's a direct discrimination where it's clear on its face. You're saying, you're limiting in your job description to certain classes, and you're possibly excluding others.
Women only,
Exactly.
right? Prima facie, on its face, gender-based discrimination.
Right.
So,
The second type is what's called a policy that has a disparate impact, meaning that it's neutral on its face. And the example in this course book was, I think, the groundskeeper needed to be 6 feet tall because height is not a protected class, but it has the impact of disproportionately discriminating against women. Maybe most women aren't 6 feet tall. I guess, certain other protected
Latinos
classes.
potentially, yeah.
Yeah. And so a BFOQ is is where we're saying, yes, we admit that this policy is discriminatory. But the reason that it's okay under the law is because, number one, the group of people that are being discriminated against can't do this job. And number two, it's necessary for the operation of the business. A more normal example of that I think is a little bit easier to understand is something like there's a law that says that commercial airline pilots have to retire at a certain age. That is considered a BFOQ because it's a safety reason, right? I mean, you can't have 100-year-old commercial airline pilots flying airplanes. But for Hooters, they must have some really good lawyers because they have been able to successfully argue that their servers can only be women because the servers are the essence of Hooters. In other words, their claim is that you don't go to Hooters for the food. Yeah, it's good, and it's potentially a secondary reason you go, but the reason you go is for the experience of the Hooter girls. And to my knowledge, I don't think there's any actual court decision on the Hooters cases.
I think they've settled them all.
They've only
Yeah.
settled them so
Yeah.
that there is no law written on whether this is allowable or not. Smart on the part of the lawyers. But something that sort of goes the other way, that just sort of rounds out exactly what a BFOQ is back in the 80s, Southwest Airlines used to only hire female flight attendants and female ticket agents. Did you all know that? And they were sued in federal court, and ultimately they tried to argue that women, their flight attendants, were the essence of Southwest Airlines. In other words, that the reason that people were flying Southwest was for the flight attendants. And the court said, no dice. People are flying Southwest to get from point A to point B. They're not flying so that they can have the experience of a female flight attendant or ticket agent for that matter.
To be fair to Southwest, I'm not trying to defend what they did, but that's kind of how that airline started, right?
Yeah.
It was the business airline, and so businessmen would travel. That was, 45 years ago, whatever it was when they started. And just so you know, when it started, it was $13 to go from Dallas to Houston or Houston to Austin. It was their triangle. They called it the Love Triangle.
Yeah.
And tickets were $13.
Yeah.
That's the way it was.
But so my point on BFOQs is that they are so narrowly interpreted by courts. I caution you to ever use them, ever. Pretend they don't exist. Do not say, well, this is a BFOQ because, short of, I suppose, running a Hooters type establishment or something where, the servers are sort of looked at as models and that's part of the experience. And really not even then, because like we just said, there's no case law on it. It's only been a settlement, which just means that the case goes away and no judge ever, writes an opinion on it that then becomes authoritative. So, this whole BFOQ thing, really, really use it very sparingly.
Carefully. Certification, certainly, if those are actually required, things
Right.
like that would be helpful.
Right.
There is something, Michael.
I think on a lot of job postings now, they have, instead of BFOQs, they have like preferred qualifications.
Yep.
So like candidates with these these or these characteristics
Mhm.
will be preferred.
Yeah, or you can say things like, experience with Salesforce is a plus,
Mhm.
something like that, yeah, or certifications in those areas, yeah, is a plus. Just to wrap up this conversation about Hooters, there's a story that goes around that I'll share with you, and it's just like Lexi talked about, you've got to prove that, the essence, so to speak. And so the story is that in one of the trials they were having before it went to the jury, here's the way this works. So if Lexi were defending, let's say, Hooters, Lexi might want to hire an expert to do some surveys of the customers of Hooters to establish their preferences, right? And so allegedly that's what happened in this courtroom in Florida, and the defense team hired a professor to survey the preferences of the male customers of Hooters. And the question that they asked this professor to establish was, what was the key aspect of the female anatomy that attracted the male customer to Hooters, right? As if that, anyway. So the story goes that the judge was listening to the testimony, and kind of in federal court, the judge can look and can ask specific questions, and perhaps, anyway, so in this particular case, the judge looked over and said, so let's cut to the chase, Professor. What exactly did you find is the preference of the male customers? And the professor looked at him and said, Your Honor, what I discovered, it was the women's eyes. And so apparently the courtroom kind of was like, yeah, sure, buddy. And the judge looked at him and said, sir, if that were even remotely true, wouldn't the chain of restaurants be called Pupils? So, that was pretty funny, yeah, for a judge. So look, to wrap up, you've got essential functions of the job and the job description. You've got these BFOQs. You now understand the distinction, and you need to tread carefully with them, as Lexi pointed out. All right, so look, we've got this job description. Now we have people applying, yeah? And we get in trouble in the screening process and in the application process. So where do you see the biggest challenges? Interviews, screening. What gives us the most trouble?
Well, you mean like legally or
Yeah,
just
yeah, legally. Yeah. Where do we get sued for?
Well, because what I was going to say is I think the biggest pitfall is not being prepared for your interview, not knowing, what roads to avoid. Because for me personally, when I interview people, I just like to be conversational. I don't want to read from a list of pre-prepared questions. You have to be careful about that, because really that's how you get off track, and all of a sudden you're talking about somebody, where they're from, somebody's nationality, and then all of a sudden they find out that they didn't get a job, and they say, you know what, that interviewer knew that I was from another country. And we talked about it, and because she was telling me that her sister is also from that country, and I thought we were really connecting on a human level, and so I'm pretty sure that I was discriminated against for that. So it's just that sort of thing, really, with those protected classes that you just want to completely avoid. The biggest things that you want to do is stick to the job description and the qualifications, and make sure that the applicant is aware of them and can meet them without going too far into it. And it's difficult. I mean, it really, really is hard when you think that you have to sort of stop yourself from asking why somebody had excessive absence at their last job and they were let go for that. Because you can't delve too far in, for example, to somebody's medical history. And if it comes out that, they had cancer or alcoholism or something, you know, and then they find out that they weren't hired, that can be an issue. I can't remember, there was something else that was written in a job description that came up, but I can't, we'll get to it, yeah.
Yes, sir.
Like, similar to the case, you know, what if you don't necessarily ask that the interviewee?
That's what I was gonna say.
just-
Yes, that's
Yeah.
exactly what I was gonna say,
Yeah.
is it doesn't matter. It doesn't matter if you don't ask, it's if you know. Because if you think about it from the potential plaintiff's perspective, even they say, well, they were aware, I brought it up, he knew that I had kids, he knew that, you know, my child was sick, or whatever it may be. I think, it was in the very first fact pattern. She said, don't worry, I didn't ask, but she volunteered, and so you were aware. And so, you know, the question is, did you discriminate, whether that was volunteered or you specifically asked?
In other words, did you use that in your decision-making policy? And
Yeah.
so best
Right.
practice is to not know, but if
Right.
they volunteer it, you've got it, and then you've got to be very careful how you make those choices going forward. Yes?
Yes, what about, so at the career fair, we had, we handed out our curriculums, right?
Yeah.
And all of my career experiences back in Caracas, Venezuela.
Right.
They already know that I am from there, right?
Mhm.
Right.
And the first thing that they asked when I approached them was where I'm from.
Mhm.
So how does that work?
Yeah, well, that's why it's so difficult. Any normal human being just in conversation, you know, especially if they're looking at your curriculum and it says right on there where you're from, it's just sort of the first thing you ask somebody. I mean, if you think about when you run into a new person and you meet them, what do you talk to them about? You know, just very basic things, and they do come up. From an employment perspective, it probably happens almost in every interview, but that doesn't mean that it's right. And from an employment perspective, if you are looking for a reason to sue, you know, today, everybody sues everybody for everything, then, yeah, that could be held against them. If you know, you suffered some adverse employment, and then you said, well, I think that they used this based on that. But again, for something like that, it takes more than just knowledge, to be honest. Just because you knew about it, you're going to have to show a little bit more to be successful in a case and to win, and to say, well, they knew this and they didn't like it and they made derogatory comments about me. And you see where I'm going with that? It's not generally just knowledge, but that's the first step to it.
Some sort of evidentiary trail that they relied on that knowledge to make their decision. That's going to be the challenge. Maybe I'll get right to you, but one other thing that you need to think about today, many of those, and I'm not trying to defend what they're doing, but they're also concerned about hiring people that are authorized to work in the U.S. And once again, that's going to get more challenging rather than less. And so they're trying to perhaps establish that. But that's a very interesting situation. We'll talk about that in a minute. Amy.
I was just thinking, what happens when you don't hire someone because you don't like the color of their shoes, and then they say it's because of where they're from? Like, how do you're like, oh no, it's just the shoes. Like, that's.
Yeah, that's why there's two sides to, well, that's exactly what happens, is then the employee, or the applicant, the plaintiff, says, you discriminated against me based on my nationality. You come back in discovery, in litigation, and say, no, I just hated your shoes. So, and then it's up to each side to prove, you know, that that's true, or get a jury to believe it.
We call that a pretext. We offer up a reason that's, the plaintiff would argue, the person that was that's alleging discrimination would argue that that's a false justification, right? The real reason was where I'm from. But as Lexi pointed out, you have to have more than knowledge. There has to be some evidence that they relied upon that to make their decision. It's challenging to prevail in employment cases in Texas.
It is, but my point to all of that from an employer perspective is what I do. I try to get people to avoid being sued at all. Because just because you can ultimately prevail doesn't mean that you're not going to waste tons of money and tons of time and effort
No.
proving that.
Yep.
So, there are obviously some steps that you can take in between the two to get from that happening. Having good employment policies and being aware of the laws and whatnot, and trying your best to follow them and document. But, yeah, I mean, you can sue anybody for anything, and you just want to do everything you can to avoid being sued at all. And then if you are sued, make sure that you're in a position to make it go away as quickly as you can. Because otherwise, this stuff drags on forever.
Long time.
Yeah.
Yeah. Yeah, so, for sure. Yes, ma'am?
Have you seen any litigation behind, I guess, maybe hairstyles? Just because I've seen an article float around, I'm not sure how true it is, about it being okay for employers, like they say they don't want to see people that have dreadlocks.
Yeah.
So have you seen anything related to that?
I haven't personally seen anything related to hairstyles, but I'm sure that could absolutely be considered race discrimination. People of certain races don't have dreadlocks, people of certain races do, and if they are saying, well, this is just part of, my hair or how I wear it or whatever, yeah, definitely, that could absolutely be considered race discrimination.
Now, they probably, though, as she pointed out earlier, they're probably not going to say in their policy, can't have dreadlocks. They're probably going to draft some sort of dress policy that has the indirect effect of precluding people that have dreadlocks. Do you remember the case I told you guys about in Dallas, where the nightclub, this is on the opposite side, this is on the accommodation, the entrance, as opposed to employment, but it's the same concept, where they said nobody can come in with facial hair. Do you remember that? We talked about that? And on its face, right, as Lexi pointed out, prima facie, on its face, it appears legal, right? But what was the disparate impact? Who did it impact more? Much greater. Men with facial hair, and primarily who? African American men, because a significant percentage, 70 or 80% of African American males, wear facial hair because they have a skin condition that's irritated when they shave, right? So that's a perfect, you cannot do indirectly what you're prohibited from doing directly, right? But your question is a very good one, because it's a perfect example of how businesses might try to indirectly discriminate by describing hairstyles that don't directly say no dreadlocks, but have that impact. Yeah, very good.
Would that apply to military though?
All bets are off in the military, Michael.
It's a whole separate
They
issue.
can do just about whatever they want.
Well, and really,
Because, military, it's like,
It's the military.
it's the military.
and the bigger issue to that, at least for me, is I represent private employers. The
Yeah.
law really is different for federal employees, federal contractors, people that, do a lot of business with the government or the state.
Right.
Let's make a point right now to save you guys some grief in your life. There is not freedom of speech in the employment sector, just so you know, right? And you agree with that? Yeah, right. So even both. It's challenging in the public sector as well. You have to be cautious. There are some exceptions in the public sector that give you some protection, but in the private sector, you really are limited, and the company can restrict what you say, how you say it, where you say it. So if I had a student one time, got a great job, her dream job at a restaurant chain, and then posted something negative about another employee on her Facebook account. And they had a clear-cut policy that you couldn't do that. And her argument was, no, this is freedom of speech. And she called me up crying, and I said, hey, it's not freedom of speech in the workplace. That right doesn't extend there. So you guys need to be aware of that, okay?
So what makes policies trump?
Law?
Yeah.
Well,
Yeah.
typically they don't. I
Right.
mean, the law is the law.
Mhm.
And so what you want to do is have policies that are consistent with the law. But sometimes you can, sort of the same way as the interplay with the state and federal government, you can restrict more, you don't want to restrict less. So, you know, I don't even know that I can think of an example right now, but you just want to make sure that, you know, if the law says that you can't discriminate against these protected classes, that your policies are consistent with that. And I can't really think of an example where you would
Well,
have a policy that was inconsistent.
Well, you could say, for instance, the federal government says you have, your race, color, creed, national origin, and gender are protected, right? But they don't, it doesn't cover sexual preference or sexual orientation or transgender issues. You can have a company policy that provides protection to those classes as well.
Yeah.
That would expand the policy. But as she pointed out, you can do more, but you can't do less. In other words, you couldn't say, we're going to not discriminate against race, color, and religion, but we are going to discriminate against whatever it is, gender. And you can't, so you can't do less. Yeah, minimum wage is another example. You can have cities and states can go greater than the minimum wage, but they can't go, or companies can go greater than, they can't go less. Yeah. But I want to make sure you didn't misunderstand. I can't remember what I was talking about when you asked that, prompted that question.
The
Free
company's
speech.
social media policy.
Oh, yeah. So, but
Yeah.
that's not, that is in compliance with the law. The law is pretty well upheld, as far as I know, Lex may know other, that companies can restrict the right of their employees to offer opinions, and freedom of speech, it's granted by the Constitution, does not necessarily apply in the private sector. Yeah, they can do that.
Sort
Go ahead,
of.
sure.
Yeah, I mean, social media is just such a chestnut. It is completely evolving right now with the courts. The courts cannot keep up with the folks in Silicon Valley as they develop these different things. As far as free speech goes, I wouldn't look at it in the context of social media. I would only look at it in the context of the workplace. When you're in the workplace or when you're representing the workplace, they can, for lack of a better term, control your speech. When it comes to social media, there have been some recent developments. Now, my professional advice is cut the social media. It is nothing but trouble. If you want to use it fine, but everything that you post, you should not put anything in writing unless you are comfortable with exactly how it is written showing up on the front page of the New York Times the next morning. Seriously. I mean, it follows you everywhere. It never gets deleted. And if you want to talk badly about, you know, one of your coworkers, then don't put it in writing. Like, I literally, even if I have something that I want to say that I think maybe I shouldn't text to my husband, I will pick up the phone and call him. We are both lawyers. That means that we are potentially covered under lawyer-client confidentiality and the marital privilege. And I still will pick up the phone and call him, because you just have to be so careful about what you put in writing. But as far as social media goes, we're talking about, and I'm sure we'll get into it more, but the labor unions and concerted activity. The courts have found that if you are posting something about your employer, and concerted activity is protected under the National Labor Relations Act, which basically means, if you think back to the old union, the old times of straight up, you know, maybe steelworker unions or whatever, it is meant to protect two or more employees to get together and discuss the terms and conditions of their employment and try to make it better for themselves. So if we work at the same restaurant and I post on his social media something about, you know, my paycheck was screwed up. I didn't get the overtime hours that I was supposed to get. And Professor Barth writes back, something like that. That is protected. Even if it is derogatory toward your employer, they can't control that, because the law takes the position that social media is really no different than just sitting talking to somebody. If I'm allowed to talk to him about it as we sit here, I'm allowed to say it on social media, even if it's derogatory to the company and more than just one person sees or hears it. Does that make sense? So social media is so widespread and vast and different depending on what particular area of the law you're talking about. Companies can and should have specific social media policies that say, my advice would be, can't post at work, and, you have to only do it during certain hours, can't do it on work devices, something like that. But there have definitely been issues where companies have tried to hold back employees from discussing the terms and conditions of their employment, and they said, no, that's concerted, protected activity. You can't get involved with that.
That's a good distinction, so it's good. All right. Well, yeah, I'm sorry, Sydney, and then Wynn had a
I
question.
had a story of how quickly things spread on social media.
Yeah?
So I work at Baker Hughes in their compliance department, and I come in one day and my boss is like, here, read this email. And it was essentially a complaint from no one affiliated with where I work. And so essentially it was a Facebook profile of an employee who allegedly works at Baker Hughes. And they, it was on, I don't know if anyone heard, but there was a Woodlands Mall shooting or something a couple months ago. And apparently the suspect was African American, and the person who allegedly was a Baker Hughes employee was going over there posting, very racist comments. He was cursing, he was saying very racist comments, and then people were like, oh my God, we see you work at Baker Hughes, how would they ever allow that? And he was saying stuff like, Baker Hughes doesn't hire X kind of people. He was just going on, and just blatant, like, you almost think, how stupid can you be? And so we were looking at like the time it was posted on like a Thursday or something. That same day, random people were contacting Baker Hughes executives saying, you either need to do something about this or we'll do something about it. And so we found out that the profile, like, when you click on like someone's picture, you can link it to see where it comes from. So it was a fake Google, like they stole the picture, it was like some bodybuilder they were using as the picture.
Wow.
All his images were fake, but he put himself as a Baker Hughes employee, like what position he was.
Wow.
But regardless of that, like within a day, random people from a different city were contacting Baker Hughes based on what an employee at Baker Hughes was saying about,
Yeah, that's interesting, and because the fake stuff is really challenging today. When you had a question?
I was wondering about the question, because when I apply for job, there's a lot of position asking, are you right now or in the future require sponsorship for H1B1? Is it the same? Can I argue that there are different nationalities when they were asking, are you authorized to work in the United States? Even though my point saying that if you are international students, you might, if you was hired a position, a management position, where you can prove it yourself that you are irreplaceable and you have particular skills that you might need a certain sponsorship in which will require the company to hire the lawyers and a certain financial sponsorship for the certain people that they might argue that you are a financial burden for a future company. Therefore, a lot of international students wouldn't be hired for a certain management position, and therefore I can argue that they are discriminating against our nationality.
Definitely. I mean, potentially. That has so many issues in that. Issues of potential national origin discrimination combined with immigration issues, combined with diversity issues. The biggest issue with national origin is that you can't directly ask the question, are you a United States citizen? The way that you get around asking that question while still legally knowing if your applicant is legal to work in the United States is you say literally that. Are you authorized to work in the United States? If you are, you have to show how, because you have to document it, and to the employer's defense, they're required to see those documents and have those and submit them to the government in their I-9 forms. So it will come up. It's not something that really can be hidden, particularly with respect to national origin. So most likely, I mean, I'm sure there are just national origin discrimination cases, but like we were saying before, just knowing, having the knowledge and being aware probably isn't going to, probably no plaintiff's lawyer is going to take that case, to be honest, to say, well, just based on them knowing because I had to show them my legal, papers to work in the United States. So you see sort of the distinction.
When I think another thing is, and Lex, you may know, I'm not aware, and I may have misunderstood, but I'm not aware that a company ever has to sponsor an employee.
Oh, I'm sorry, then I misunderstood the question too. Was that?
I don't think it's an obligation. I think that's an agreed-to concept.
So they don't have like an obligation, it's like they don't.
Well,
What's it called?
Well, I think your concept is that-
They have to sponsor?
is it an affirmative action issue? See,
Yeah.
because that's the other problem with what we were saying about diversity is it depends on if it's a public employer versus a private employer. Private employers aren't really subject to affirmative action or diversity. There really is no diversity law, but requirements. But the federal government, certain state and federal agencies are subject to affirmative action issues. So yes, they will require that paperwork and be required to sponsor certain things, I suppose, if it's a
I
part
don't
of an
know, that's a
affirmative
tough
action
one.
issue.
I don't know, yeah, it could, but that's a tough one.
Yeah.
Yeah.
Sorry, you
Yeah, it
stumped
certainly
us.
raises a good issue,
That was
yeah.
good.
It is an agreed upon.
Yeah, it's an agreed upon transaction. This part of your employment agreement will agree to sponsor
There's
you
no
if you agree to
requirement.
stay so long. But I'm not ever aware that they actually have an obligation if you somehow you prove to the company you're irreplaceable or, that nobody else can do it. I still don't think they have an obligation. I think it's up to the company then to prove to the government that you're the one that brings that skill set and that they then can decide if they can get through. Did you have a question? Nope, y'all good? Oh, yeah.
Just about the internet laws, Facebook thing, like if there's a part, on Facebook where you put in your employer, who you work for, or your
Yeah.
job.
All right.
Yes.
So if something goes wrong, couldn't the employer then argue you're representing my company because you have on your Facebook page that you work for me?
Yes, and I think that all the time. Do you guys ever read just any online news source in the comment section, and it'll say Stephen Barth at
Great.
Hilton Hospital? Like
Yeah.
it says right there. So if you're writing something derogatory or you get into it with total strangers online, right there you're saying this is my name and this is where I work.
Right.
I mean, you want to protect your, not to be on a soapbox, but you want to protect your reputation and your work with your job as best you can. And so you don't have to put employer there though, do you? A lot of people do because they just think, well, this is part of my profile. They don't know that it's necessarily going to come up every time they make a bad comment about
Stuff on
something
LinkedIn
online.
and stuff.
Mhm.
Yeah.
Because you use that network to help you get a job, so you want to put your employers
Good
there.
point. Yeah.
Because
Right.
there are laws that you have to take your company's best interest.
No, I mean, there's no law. Typically, at this point, because social media law, as it is not really existent right now. I mean, it's just catching up. So basically, anything social media related, or mostly 80%, is going to be the company policy on it. But that doesn't necessarily mean the company policy is legal, which is, again, why you just want to use your best judgments.
At your own risk.
One of the things we haven't talked about here, though, is the rights of privacy of the employee in the workplace and on social media. So employers, they don't have the right to surreptitiously get into your accounts, do they? I don't think so.
No,
Yeah.
not unless you've filed a lawsuit.
Then,
Yeah, and that's something, there are a couple, go ahead.
Sorry.
That's okay.
On that, I had a coworker who was a police officer, and in his uniform, he took a picture. His Facebook was completely private, nobody could see it. He took a picture of himself in uniform. During Walking Dead season, there was this filter that would turn you into a zombie. And he took a picture of it, of himself in that filter with his uniform on, and he got written up for that. Are they allowed to do that?
Again, that's
And they did not have a policy at that time.
right, that's a governmental.
Public.
Yeah, that's a public employer, so it's different than a private employer. So free speech is different, and I'm sure they're allowed, well, I'm not sure they're allowed to if they did do it, but I would say he should look at what his policy, you said there was no policy on it?
No, it was for the university. And
Oh.
they didn't have a policy.
Oh, really?
He was a police officer for the university?
Yes.
Okay, well,
Yeah.
yeah, if he was a police officer for the city, those folks are typically unionized, and his remedy would be to go there and ask the union to support his, right, and to complain and appeal it. Here, though, I don't think they are unionized, so he's kind of on his own.
But I do have
And that's tough, yeah.
2 other points on social media. I could talk for hours about this. The first question I have for you guys is, who here thinks that when you're, when you are interviewing somebody and doing a background check, that you, as part of the background check, can check out their social media? Who thinks that's okay? Why?
Because it's public. I mean, I don't know, I mean, it's out there.
It's gray, right?
I say social media is fair game.
Who thinks social media isn't fair game?
Technically, it belongs to the company you signed up for, because when you signed for you surrendered all that information to them.
Your terms of use, you think that has
You
an
do?
impact?
You gave them your Facebook username and password?
Oh,
when you
no,
signed
not
up
the
for-
company, he's talking about
No.
Facebook owns all the information.
Oh,
not,
oh.
Yeah, yeah.
Okay.
Yeah, right. You were getting ready to get it, buddy.
Yeah,
You-
because
you-
that's
no,
the
no.
second issue
No,
that I
yeah,
wanted to
no,
say.
no.
Yeah.
But the first thing is, maybe. The thing is, just like we were saying before, even if you don't ask it directly, if you can't find out through, a conversation with somebody, you can't find out on Facebook. So if you, when we're talking about maybe they have a drug use problem or excessive alcohol or something that you can see through their Facebook photos, if they find out that that's how you knew, it doesn't really matter, like we were saying before, how you find out. If you become aware and they believe, and there may be some other circumstances that lead in the direction of discrimination based on something that could potentially be a disability, that's a problem. You definitely, background checks are so gray also, because there's a lot of issues with potentially credit checks, and that's been seen by the courts as discrimination toward minorities. But yeah, for generally looking at somebody on Facebook, you probably don't want to do it, even if it is public, because you could stumble across something and you could be saying to yourself, whoa, 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 this is not the kind of person that we want to hire. But then what have you done? You've potentially discriminated against them.
You might see their age. If you don't, if it's not an age BFOQ, you could see their age. You could see lots of different things.
Yeah.
So yeah.
Well, I guess I was like falsely under that impression, because at my previous university, I worked for one of the offices on campus, and there was a position open, and one of the ladies that was hiring for it told me, she said, we're getting ready to hire for this position, and she was saying that this woman that had applied, she looked her up on Facebook, and she said we were getting ready to hire, but they saw something on like her cover photo or something that she had written on there that was distasteful.
Yes.
And she said, we're not next candidate.
Right.
So I was kind of wondering, I'm like,
Now remember though, because it gets so confusing when you start thinking this sounds wrong, that it smells wrong. But again, you have to be a member of a protected class. We're talking about information of being part of a protected class. So for that instance, maybe, yeah, it smells wrong, but what protected class was that person a member of? What did they say that was distasteful? I don't know. I guess I'd need a little bit more information on it. But you see where I'm going with that? You're not just, it's the same thing where we can not hire you because we don't like the color of your shoes. We cannot hire you because we don't like something you said on Facebook. My point is a little bit more toward, you don't want to learn something that you couldn't ask directly in an interview.
Yeah, so it's good. It's a tough one, but that gets back to her point about you guys be very careful what you post. Especially today, people don't see things eye to eye, and so you want to be cautious about that, right? You want to give yourself the best chance to get the job that you want, yeah? So be cautious about that. I do want to talk just a little bit more about interviews for just a minute, because look, you can, carry on conversations with people. As Lexi pointed out, you want to be very cautious, yeah, about how you drive it. So when you talk about think about your job descriptions. Just don't think about the skill set. Think about the interpersonal skills also that you want. Are they resilient? Yeah? Do they have grit? Do they persevere? Do they, Are they organized? And then you can talk about things like that. Give me an example when things didn't go well at the last job, and how did you handle that, right? The idea is keep things focused on the work, right, that they're going to be doing and the work performance. And so you can find out a lot about people without getting outside the scope of the job itself, right? So think about it that way as well. All right, good. So we have other tools, we've talked about them. We can test for drugs.
At a point.
To a point, all
Yeah.
right. Yeah, you test for drugs, and you want to pass the drug test, right? That would be something you want to do, right? Everybody should have that as a goal, passing their drug test for the job, I would think.
But
Yeah.
you want to be careful when you do it. Who here thinks it's okay to test every applicant for a drug test? Or even interview them, maybe? Anybody think that's okay or not okay? After the what?
After the hire.
As a condition of employment, yeah. Because what you're trying to do is narrow the pool of potential plaintiffs. I mean, you almost have to, it's terrible to say, but you almost have to look as every applicant has something, you know, where is an issue going to come up? What's the most dicey? Drug tests. People don't love them. So you want to say, you know, this, we have a no drug policy, and this is a condition of our employment, and we test everybody as a condition of their employment.
The other time you want to test for drugs is after a workplace accident. Because one of the very few remedies you have, if not maybe the only one, for a workers' comp claim, is that somebody was under the influence of drugs or alcohol at the time of the injury. So you want to make sure you test at that time as well. You can do random testing throughout as well if you want to, right? Which I think is a good plan. I always get asked when I do talks is that I know I can test incoming people for drugs, but can I test people that have worked for me for a while for drugs?
Yes.
Yes, but I always tell them, you may want to give your current employees about 90 days notice before you test for drugs. You may not have any employees after a while. I had a guy at a ski resort one time in Colorado. This was 25 years ago, and I said, look, put a sign up that says we test for drugs, right, and that will narrow the pool. And he started laughing, and I said, what's so funny? He goes, I run a ski resort in Durango, Colorado. He said, I have to post a big sign that says, we never test for drugs. He said, or I would never have any employees. And that was 25 years ago. You can think about what it's like today, right? So let's talk about one other really touchy area in the screening. Well, let me make sure, one of the best pieces of advice I think I ever got in terms of applications was the only person that writes on the application is the applicant. Don't take notes on the application, don't mark it up, right? Because we get extraneous notes sometimes, and as Lexi pointed out, those notes are going to be used against you and considered against you if litigation ensues. So try to
Nothing
make,
in writing?
is that what?
Nothing on writing?
Very little.
Very little, but especially on that application. Don't take extraneous notes because it's hard to explain what you did. And a lot of people use code words on applications, and you want to be very cautious that you don't get caught up in that.
Because these are the documents that get produced.
That's right.
In a lawsuit.
In litigation, yeah.
Yeah.
Even circling something.
Circling something you want to be cautious about. So the only person that writes on the application is the applicant. I found that to be a very effective rule to keep you out of trouble, so I would encourage you to do that. Let's talk about criminal history checks for a minute, because those are challenging. Now look, it's not possible for us to sit here and talk about every state in the country, right? And so some states are much more restrictive about what potential employers can ask and what they cannot ask. So you want to be cautious. What I encourage people to do, and we'll hear from Lexi in a second, is I encourage you to, one of the challenges we have is you got a lot of criminals out, people with criminal histories applying for jobs, especially in this industry. If we didn't hire people with criminal history, we might not have many employees. If we don't have employees, we don't have customers. So I encourage you, and I think we're probably headed this way across the country, is to not blanketly exclude people with a criminal history, but make sure that it's relevant to the job position, right? So if somebody has a theft in their background, well, you probably don't want to give them access to the hotel rooms, right? Things like that, master key systems and things like that. But any other thoughts about, yeah, traffic tickets or DWI, you don't want them driving the bus, right?
Yeah, I think that's great advice. I also think you want to limit the time period. If somebody got arrested
Yeah.
when they were a kid for doing something stupid, and here they come to you 10 years later, factor that in. I mean, you don't, like we were saying, you'd have no applicants, no employees. Everybody's
Yeah.
done something stupid.
Yeah, yeah.
So.
Yeah. So-
Has there been, when I took employment discrimination, well, class was 2 years, there was, my professor mentioned some recent developments in the bandbox area.
In the box, uh-huh.
So has there been anything in that area lately? I don't know about Texas.
I was going to say not in Texas to my knowledge, but yeah, a lot of people, do you guys know what Ban the Box is? It's if you have just a standard employment application and it says check here if you have
You can
ever
see it
been
in the
arrested
textbook.
or-
There's a sample application. It
Yeah.
has a little box that you check if you've got that.
And so there's been a movement in the different states to try to get that banned because, it potentially discriminates before.
So you can have it in Texas?
You can have it, typically it's just part of, a standard downloadable form, but you don't have to.
Right.
And I probably,
In some
would maybe
states.
say it's not the best idea. Again, sort of like a drug test, wait until you say, I want this person, and then drug test. And as far as that goes, you obviously can make the determination, say you have somebody that you think is going to be a really great employee, a condition of their employment is criminal history check. You find out that they've done something, it's up to you to decide, generally speaking, if you want that person or not. But the thing that I would caution you on is most likely your company is going to have some sort of policy on it. And a lot of times where people run into trouble is when people are made exceptions to the policy. They say, well, this was, I got the job even though I committed a felony 15 years ago,
Yeah.
but the other person committed a felony 20 years ago and didn't get hired. So that sort of is advice for across the board on every policy. Probably one of the biggest reasons companies get sued is for being inconsistent, playing favorites, excusing certain things and enforcing others. If you have a policy on it, enforce it across the board, make notes, document it, have files, so that when an issue comes up, you say, here's a proof.
Yeah. And if you're not going to enforce it, you need to get rid of the policy.
Right, yeah.
So it's interesting, and the other thing is, remember, people are innocent until proven guilty. So when you ask the question, you want to ask about convictions, right? Not just, have you ever been charged with? That can be open a whole different situation, right? And then the other thing that I think is important, but and there's kind of different, two schools of thought on it though, is, a lot of people get charged with things today, and then it gets predisposition, or what we call deferred adjudication. So I do think you want to, my preference is, you want to ask about those. Have you ever had a criminal charge dismissed via deferred adjudication? Because somebody could have a couple of those in a driving under the influence thing, and if you don't ask that, and you put them on the bus, and then they're drunk, and a couple of people die because they're going back and forth to the airport, and they're drunk, and right? That happens, and you didn't ask, and you didn't check, then I think you might have some challenges, because those types of things, those arrangements, don't always show up in the criminal history background check that you might do. Because they can get, and so then you're relying upon their truthfulness in answering, but nevertheless, I would still encourage you to ask. It's a challenge today. You want to protect the applicant's rights, but at the same time, you want to hire well so that you don't get sued. Well, we got a few more minutes with Lexi's time. I want to get into the collective bargaining agreement, the union and the collective bargaining things for just a moment. Can you talk to him just for a minute about a collective bargaining agreement and kind of what that is?
Yeah. Well, like we were saying before, there are some exceptions to the at-will employment doctrine, and the collective bargaining agreement is one of them. Basically, it's really complicated in that there are a lot of laws that apply to it, but the concept of collective bargaining is really very simple. is, generally a union issue where you have employees who elect a representative to represent them to the employer on issues that are really important, like minimum wage or overtime hours, something like that. So if you are subject to that collective bargaining agreement, then that is what governs the terms and conditions of your employment.
Yeah, and you got to recognize, so if you go to work someplace as a supervisor, executive, or manager of a hotel or restaurant group, and they're unionized, and there's a collective bargaining agreement in place, you have to spend time with that. And you have to realize that that's going to govern a lot of, if not most of, your disputes with your employees. So you've got to get to know that document really, really well. And then there's all kinds of rules around protecting their employees' rights to organize, and we talked about communications on social. So you've got to be cautious if you go to work in that. If you go out to Vegas, if you go up to New York, if you go down to Florida, if you go over to Hawaii, some places in California, you're going to have extensive unionization in the lodging industry. And you've got to understand what that means, and you have to realize that a lot of your rights as an employer are going to be restricted.
Yeah.
And so you want to be aware of that.
Unions are very powerful,
Yep.
and pretty much everything that we've talked about up until this point, I don't want to say it all goes out the window when there's a CBA, but kind of. I mean, that contract is the very first and most important document that you look to whenever you're making any kind of employment decision. Texas is a right to work state. Does anybody know what that means?
Yeah, don't confuse right to work with employment at will. Go ahead. I'm sorry. Let's say something.
Yeah. Wait, am I confused?
No,
Oh, okay.
you're not. No, you're not. No, not you.
Okay.
I want to make sure they
Does
don't.
anybody know what a right to work state is? Okay, that means that you can't be denied employment on the basis of your joining or not joining a union. And so, but well, there have been definitely some issues now with people not wanting to be part of the unions, and that sort of causes problems because the people that are part of the union bargain under the collective bargaining agreements. And even, to make it more complicated, even if you're not in a union, you still have protections under the National Labor Relations Act, just like we were talking about concerted activity. You don't have to actually be in a union, God bless you, to have concerted activity. So it definitely gets confusing, but my advice would be when there is a CBA, honor it, go to it first for any issue, and then if it's not covered in the CBA, then you go to your employment policies of your particular company.
Yeah. And just to make sure you guys are clear, she was talking about and why this is such a challenge for people. So the right to work state, you see how that's different than employment at will. Totally two distinct concepts. Yeah? Right to work is just as she said, you don't have to join a union in order to work at this particular place, but you still get the protection of the collective bargaining agreement. So if you were a dues-paying member of the union, you get the protection. But now all of a sudden you're paying dues and you're the one that's supporting it, and then somebody else comes along and they don't pay dues, are you going to be okay if they get the protection? Well, that's what happens. And so it's a real challenge. So if you're not in favor of unions, you want to push right to work because you want those people to come on and take jobs, and so that's one less employee that's supporting the union, right? And it creates disruption for the union. You've got to realize that employers and unions, they don't always see eye to eye. But listen, be cautious about that. Don't fall into the trap of thinking that unions are necessarily bad. My perspective of unions is if you show me a union, and at some point in time, I'll show you poor management. Right? Well, you think about it. Why do people unionize? Well, because they're not being treated fairly or kindly or equitably. I think I gave you the example of Aruba, didn't I? Where we would go down there and there were 5, 7, 8 hotels down there on the island at the time, more than that. But anyway, there was only one that wasn't unionized. It was the Hyatt. It happened to be a U.S. brand. But we would say to those folks, why aren't you unionized? They said, we don't need to unionize. They treat us fairly. They treat us equitably, right? So we don't need to unionize. So I encourage you to do that. Now, here's the last piece I want you to think about unions. A lot of people that complain about unions belong to unions themselves. Every hotel owner I know that complains about a union belongs to a franchise association. Well, the only difference between a franchise association and a union is the way it's spelled. All right? So don't get too carried away a union bashing. Doctors belong to unions. They just don't call them that. And today, they're all, they may not be bargaining collectively, although doctors probably are with insurance companies, right? Hoteliers are with a franchisor. Yeah, but most of your business associations are quasi or high, they're unions, they're not bargaining for something in particular except for the government. They're lobbying them, right? So don't hop on that bandwagon too quick where you bash unions. Now, do unions have challenges? Yes. In my experience, most unions become what they hate, right? Bureaucratic, inflexible, and retaliatory in some instances, but doesn't mean they have to be. And the Unite Here union that focuses on hotel and restaurant employees, don't kid yourself. That's a very powerful union. It's one of the most powerful unions left in the U.S., and it's growing. And they're smart. That got started, here was the hotel and restaurant union. Unite was the union of textile workers over in the southeastern United States. But what happened to the textile industry in the United States? It all got shipped overseas. So that union went, but that union had a lot of money. The restaurant union, the hotel and restaurant union, didn't have any money, but they had lots of employees. Why did the textile union have money and the hotel and restaurant union not have money? Even though all their workers were gone, the Unite still had lots of dough. Why? Because they got paid higher wages for a longer time because their union was in place. They had bargained for much higher wages, so their dues were significant, and they had generated a lot of revenue and saved it. The hotel and restaurant employees they didn't get paid high wages, right? For a long time, this industry wasn't unionized. So what did those two groups do? Well, if somebody's got money and you got people and you need both, what are you going to do? You're going to form a union. So they unionized together, and so that's why it's called Unite Here. And these guys are bright. Here's what they tried to do in Atlantic City and in Vegas. They tried to make all of the CBAs, the collective bargaining agreements, expire on the same date of the same year. Now, why would you want to do that if you're in the union?
So you can renegotiate?
So you can negotiate. Why? Why does that give you leverage? Why is that important? If employees go on strike at one of your hotels, what are you going to do as a management team? You're going to bring your management team into work and fill, right? But you're going to bring people from where? Your other hotel. Well, if every contract expires on the same day and everybody walks out of each of your hotels on the same day, you can't cover all those hotels. That gives the union huge leverage. And it took these hotel groups and casinos about a year to figure out that was happening because they were all negotiating separate and not the same lawyers were doing it. But once they did, they were like, well, I won't tell you what they said, but they were like, uh-oh. You guys, there's a lot going on out there in the union side, a whole lot. You need to be mindful of that. Well, let's say thank you very much to Lexi.
Thank you guys for having me. This was
Yeah,
great.
that was great insight. Thank you very much.
Thank you.
Guys, why don't we take a break? I'm going to walk her out. If you want to visit with her you got a few minutes?
Yeah, definitely.
If you want to come up and visit with her and maybe share some contact information, that'd be great. And then I'm going to walk her out and get her parking situation taken care of, and then we'll come back. And yes, we're going to spend a few more minutes in class. So don't think like we're leaving just because she's leaving.
Yeah, thank you guys.
Okay.
It was really nice getting to spend time with all of you. And I'll leave some cards if you have any questions, things that come up. Feel free.
Yeah,
okay.
Thanks for coming.
Cool. Yeah, thanks
great.
for having me. All right.
Break time. Somebody remind me to go back off of mute, will you guys? Okay, guys. wait for Lucas. He was kind enough to escort Lexi down to her car, so, but let's talk for just a moment. When he gets back, I've got a little assignment I want you to do. It'll take 30 minutes, and then we'll call it a night, all right? Is that good? Yeah, all right. Yeah, because I realized last time I kept you all time. You guys probably weren't used to that. You're like, what's up with that, dude? Yeah, keeping us the whole class time. What's up? But I do want to talk for just a minute about the international student situation. I think that's challenging, and I know it is, and I'm sorry it is. And unfortunately, as you know what's going on in our country, it's going to be even more challenging. So you need to, let's do this. I want you to get in teams of 3, which I will assign. I'll do the random thing again, right? I'm getting pretty good at that. But here's what I want you to do. I want you to take 30 minutes, no more. And I want you to create a job description and bona fide occupational BFOQs for an executive housekeeper at a major hotel. Now, do not go online and find one. So do this on your own, right? You guys have this. I just want you to reinforce the essential functions of the job, yeah? And I want you to think about what those BFOQs might look like, okay? And then everybody email it to me, each team, right? Same way you did last time, 6309, date, with the PeopleSoft numbers, all right? And then we'll come back after the 30 minutes. If you don't want to stay in here because it's cold, you guys can leave and go sit someplace else. It's actually gotten a little better here just the last few minutes. But you're welcome to go. I'd rather you not go have a beer in Eric's, but short of that, you can kind of do whatever you want to do. Yeah, right? Yeah. Some of you in the back are going, how'd you know? So do you understand what I want? Job description includes the essential functions of the job for an executive housekeeper. You guys you might have to, who's ever in Sydney's group might have to help her with an executive housekeeper position for a hotel, right? But you guys know what is required there. And then you need BFOQs, right? That we think can pass muster after the discussion that we had tonight with Lexi. All right? By the way, what'd you think of Lexi? Yeah, would you have her back?
Yeah.
Oh, okay, good. She was nervous. She's a little young. But I thought she handled herself really well.
Yeah.
Yeah, you guys, by the way, you asked great questions. So that was fun. So really good stuff. So thank you. It's good discussion. Time went by quick. All right. So I need to put you in teams, right? Yeah, okay. So I need to start in a different place today. Hold on. I'm not counting yet. I'm just counting to myself. You know exactly what I mean by that, yeah. Okay. You ready? Michael, you're a 1. Danny, a 2. Olivia, 3. Lila, 4. Arena, 5. Laura, 6. Leah, 7. 8. 1. 2. Win, you're 3. 4. 5. 6. 7. 8. Yes. 1. You're 1. 2, 3, 4, 5, 6, 7, 8. And then you 3 are on a team. How'd that happen?
Did you say 9?
I thought I had 26 people. Is anybody a 9?
Oh, you're right.
No, I thought I did 8.
Okay.
Don't, Cindy, don't mess up my counting. All right, everybody go? Where are the ones? Go. 8. 2, 3.
7.
7. All right, you 3 are good. Okay. I don't know how that worked out, but you guys hang on. I messed that up somehow. Hey guys, how are your videos coming? Yeah. Don't everybody speak at once.
You were five?
Who's out? Well, you got 7 minutes, like, is there?
Who's out there?
Yeah.
Who's out there?
Yeah, you can take still photos and embed them. You can have a video clip and embed it. Yeah, you can do that for sure. Videos of you speaking, so you can mix and match all of that. Okay.
Okay, so we were just kind of getting, well, at least my group's been just doing videos of.
Different aspect. You can do that,
And
yeah.
then having voiceover.
You can do that.
Okay.
Yeah,
Proof that we did.
that's exactly right. You can do that.
I'm still waiting on the 4 seasons.
Yeah, one.
Oh, you are?
Yeah, like it's been approved, but he
Yeah.
set me up with the director of security
Yeah.
who hasn't contacted me.
Okay, that's a good hotel for you to do. Yeah, we gotta do it. Yeah. Yeah, right. All right, if that doesn't happen pretty quickly, let me know, and I'll get you connected with somebody else, okay? All right.